let me begin with an apology. We had a malfunctioning Zoom link, and then I had to make a few attempts to send out a link that worked and then get everybody in. So if you had trouble logging into our workshop today, I apologize, and I'm so glad you're here. So welcome on behalf of everyone at the JFF team to what is our first workshop for the year 2022. Let's hope that 2022 turns out to be a kinder year to us all. Please keep your mics on mute.
Congratulations.
Please make sure that your mics are on mute, except when you're speaking, please. Thank you. So I'm Dinesha Samararatne, for those of you who don't know me. I teach at the Faculty of Law at the University of Colombo, and today I will be the chair of the panel. I just also want to make a very quick announcement. We are anticipating power cuts in Sri Lanka. So if I'm disconnected from my call, my colleague Swati Javeri will step in. So please do bear with us if that happens. So very quickly about JFF. JFF is a virtual forum for law teachers who work in South Asia and who work on topics related to South Asia. And the JFF team aspires to nurture and cultivate a community of like-minded scholars who can share work in progress, give constructive feedback, and talk more generally also about what it means to have an academic career in the law in the South Asian context. So turning to our paper today, we have a very exciting paper to be discussed, and we are delighted to have with us Abu Sayeed, the author of this work in progress. Abu Sayeed is a PhD candidate at the University of New South Wales in Australia, and his paper is titled How to Do Basic Structure Review. To comment on his paper, we have a really exciting lineup of discussants, and I'll introduce them very briefly today. We have Surya Deva, Professor of Law at Macquarie Law School at Sydney. We have Professor Rosalind Dixon, Professor of Law at the University of New South Wales, also in Sydney, and Professor Ridwanul, who is Professor of Law at Dhaka University. Coincidentally, our authors and our discussants are all based out of Australia today. So thank you for joining us, though it's late for you. So as per our usual practice, we will consider the paper as pre-read, and we will invite our discussants to comment on the paper. And Sayeed, if you wish to respond, you may, but there is no expectation whatsoever. So once the discussants respond, we will move to an open discussion, and we will conclude in 1.5 hours. So let's begin, and may I invite Surya to begin, please? Thank you.
Thank you, Dinesha, and thank you all the colleagues. And I would like to congratulate Sayeed for writing an excellent paper. I thoroughly enjoyed it and learned quite a bit. So I think that is a very good start in my view. I have certain observations, comments, questions, and suggestions, and I will go through them in the random order in which I made notes while reading this paper. Let me start with the articulation that the basic structure doctrine is extra textual. And I was wondering that may hold true in the context of Keshwananda in India, but that may not be the case everywhere. So I was wondering whether you may need to consider it in a more holistic manner, because sometimes the doctrine could be part of the Constitution expressly, and in those cases, it is not really extra textual, rather it is part of the text. So I think that sharp distinction that your paper draws between something which is extra textual, and then you draw this analogy with the tribes' invisible constitutions, may not hold true, I suspect, in relation to all the constitutions where this kind of a doctrine is there. And I think perhaps that is where also I would say that this idea that this doctrine should be relevant in the context of the original constitutional text or not, is it going to restore that and all that issue? there also, I think we need to consider what is the original constitution. And I think you, with reference to the Siddiqui judgment, you referred to the reasoning of Justice Sinha, that what is the original constitution? And perhaps I tend to agree with the logic that the originality need not be traced from the date the constitution is adopted. Rather, we can think of originality in a retrospective way as well. So let us consider some of the interesting developments. Right to property in India, for instance. Right to property was a fundamental right in the original constitution. It was abolished by a constitutional amendment. And hypothetically, if right to property is reintroduced in the Indian constitution, so then the question is, what is the original intention, or what is the original constitution? Was it the original of 1950? Was it the original based on the understanding of right to property in between and the socialist insertion in the preamble, or the free market economy, post-free market economy reforms in India, or the current, if it is reintroduced, what does it going to mean in terms of the original understanding of that? So from my perspective, I would consider basic structure doctrine as part of a wider system of checks and balances. And if we see it in this particular manner, it need not always be part of this invisible or extra textual. Rather, it could be part of the constitution. And if there is a potential conflict, either with an amendment or the original text of the constitution as you articulate, then this is more about a harmonious interpretation of those provisions, including of the basic structure doctrine. And again, you draw an interesting distinction between the textual structuralism of Justice Matthew and purposive structuralism of Justice Chandrachud. And I was wondering that it need not be, again, this sharp either or distinction, because let us take right to equality as an example. So in the context of Indian constitution, you may argue that right to equality is part of the basic structure doctrine, and you can justify this with reference to the text of Article 14 and 15 and 16 onwards. But you may also take an alternative argument and say rule of law is the basic structure, and rule of law implies right to equality, and that's why even the purposive structuralism could be invoked to justify it. So what I'm trying to say is that those distinctions that your paper draw are very useful in my view. They force us to think how different cases and judges are articulating those propositions. But should we be dogmatic about those distinctions that your paper drawing? And many situations may not really fall into one of those two, or it could be both of them together in those particular situations. Let me make a couple of final comments. And I think that is my big concern with perhaps your articulation that the doctrine may also be relevant against the original text of the Constitution. Because if we look at the application of this doctrine in several jurisdictions, what I believe is that it has become a self-serving doctrine for the judiciary. And that is a dangerous situation. We should not assume that parliaments are suspect and they suffer from democratic deficits, and that's why we can't trust them, and we need this checks and balances coming from the courts. But we should not also assume that the courts are always going to do the right thing. And I would also like to make a distinction between courts and judges. In India, Supreme Court is not really a court. It is individual judges with different personalities and orientations. And if that is the case, we don't really have a constitutional court with established traditions applying the doctrine of basic structure in a consistent manner. Rather than we have these individualistic judges with whatever orientations they have. Some of them may not be very strong in terms of their normative understanding of the Constitution. Some of them may not be independent. Some of them may be very progressive and some may not be. So then this could really backfire. Let me take a very concrete example, which I also discussed in this recent book about the Article 370. So if we go by your argument and we take the abrogation of Article 317 in the Indian Constitution without any constitutional amendment, it is quite possible that the government may argue, and here you discuss Ganpat Rao. So similarly, like Ganpat Rao, the government in India may argue that abolition of Article 370 is not abrogation of basic structure, rather it is restoring basic structure, because we are trying to establish parity amongst all the states and equality and all that. And if Supreme Court is going to be persuaded by that argument, in my view, that will be a regressive use of the basic structure doctrine. So I think that is my worry, that the courts can use the doctrine in a self-serving way. And I think that has been the case, whether in Sidki or the judges' cases in India, a pattern of the judges' cases, courts are basically trying to protect themselves. We can't really assume that if judges have all the powers, that is necessary to maintain independence. That is perhaps an overestimation of what is independence of judiciary. My last point is that you talk about an amendment of the Constitution, and I would like you to consider that sometimes the amendment of the Constitution need not be formal. And in this recent chapter, in which many of us contributed in this book edited by Pojan, no, not Pojan, I'm forgetting. Yes, you know what I mean.
Yeah.
What I try to discuss is that there are two other possibilities of constitutional amendment. One is judicial interpretation. So the court can, by its interpretation, amend the Constitution. So in those cases, should we apply the basic structure doctrine even against the judiciary? And I would link it with towards the end of your paper, you talk about legitimacy of the doctrine, and you mentioned process and outcomes. Can we add a third element there? And the third element is, can the courts self-subject themselves to the doctrine? So hypothetically, a lawyer can argue that if the court is likely to decide this case on those lines, that is likely to breach the basic structure doctrine. And I think that could be, in my view, a check and balance against the courts and judges trying to use the doctrine for a self-serving purposes. And of course, the other possibility of informal amendment is like Article 370, where Article 370 is taken out of the Constitution for in effect, but without any constitutional amendment. So they could be a law having the effect of constitutional amendment. So would you be open to use the doctrine in those situations where we are not talking about a formal amendment, but it could be the interpretation, or it could be just a ordinary legislation having the effect of amending the Constitution? So I think these are a mixture of questions, comments, reflections, but overall, let me conclude by congratulating you with writing an exciting paper, and thank you everyone for giving this opportunity to read this paper and join this conversation. Thank you. Back to you, Dinesha.
Thank you very much, Surya. Ross, I would like to invite you now to give your remarks, please. Thank you.
Thank you, Dinesha. Thank you for the opportunity. It's a great pleasure to be part of this forum, albeit as a guest. I really admire the aspirations of the forum to create the kind of community that you are succeeding in creating here. And I really want to acknowledge the organisers and the vision and energy behind it and how important it is. It's absolutely delightful to have so many South Asian colleagues in Australia as part of this. And I think that, you know, Australia and South Asia share a kind of Anglo common law responsible government tradition, which means that even though we have such diverse political and social contexts and different challenges, it is actually such a natural connection and way of continuing a dialogue which had more negative colonial origins and roots, but which finds positivity in renewed forms of dialogue of the kind that this is a sort of example of. So Sayeed, I really enjoyed reading this paper, and it's very thoughtful and sophisticated, and I enjoyed seeing you rebut some of the arguments that David Landau and Yaniv Rosnai and I have advanced. So I want to say that the distinction you draw between prohibitive and permissive uses of the doctrine is useful. I like how you identify the kind of duality, or what Habermas might call the Janus-faced nature of some of these decisions, as both nullifying and validating at the same time. And I think that seeing the kind of duality is very interesting. And the way in which you state that, I think, is very useful and interesting. I noted in the chat that one of the things that both Professor Sam Zakharov and I, and then separately Tina Surya and I, have noted is there is actually a tendency in the unconstitutional amendment doctrine for courts to strategically deploy a mix of prohibition and permission. So to basically uphold an amendment while warning that they might not do so in the future. And I thought you might find that moderately useful. I want to focus, however, on the claim that you've noted about the text structure relationship, and raise one sort of friendly challenge and one more fundamental challenge for you, and then close by echoing Surya's comments about the potential for abuse of any doctrine of this kind. So I think the claim that there's, in a sense here, a competition between text and legalism and a more structural interpretation seems right and helpful. And you make a persuasive case that structure may dominate in some cases. But in some of my recent work on responsive judicial review, which a couple of you have generously engaged with, one of the arguments I make is that we may need, if we are committed to any form of legalism, to give a sort of additional or extraordinary justification for textual departure in favour of structure. If we can accommodate text and structure together, obviously that's the ideal legal kind of approach, but if one has to disregard text in favour of structure, I suggest maybe some sort of additional argumentative burden has to be satisfied. An argument that there's an especially urgent injustice, an irreparable harm, something that really justifies judicial intervention to depart from text so clearly in favour of structure. And what I wanted to ask you is your position that structure always dominates over text, or are there particular conditions under which you think that's the case? The second question, which I do think is a little bit more challenging for you to answer, is about how you think about the arguments that are made by people, some of them quite radical critics of constitutionalism, others, totally proponents, people like Vicky Jackson and Mark Trushnet, where the argument is that constitutions are always incoherent packages, that they are a combination of principle and compromise, and that there is no basic structure that one can identify in an original constitution because it's an amalgam of different ideologies, interests, priorities, and that the compromise inherent in them is what gets them over the line, but it also makes it very difficult to say, well, aha, these provisions are the core and these provisions aren't, because it's all a package. Vicky Jackson says that about federalism, other people say it more generally. And of course, that's used as a critique of originalism, but it's a more general point about constitutional compromise makes it hard to identify a clear basic structure. And the last thing I want to say is that one of the things that David Landau and I, in our recent book, Abusive Borrowing, warn against is that some doctrines are especially susceptible to abuse. And I think that one can't guard against that fully, but one can be mindful of it in how one goes about setting up per doctrine or justifying it. And so my question, picking up, I believe, really where Surya's left off about and thinking about the self-serving aspect of the UCA doctrine in India and other places, are there ways of constructing an unconstitutional constitution doctrine that is a bit more mindful of the possibility of abuse, which I think that part of where Yaniv and Dave and I are coming from is that Honduras was potentially abusive. And so can you think of any ways of cabining your endorsement of your structure over text unconstitutional constitution doctrine that is more protective against abuse? Hard to do. Maybe there's no way of doing it, but I'd be interested in your thoughts on that. But this is a really great paper, and I enjoyed reading it. And you know, I'm looking forward to learning more from you and others about the specifics of the case in context, because I read it obviously from a broader comparative perspective.
Thanks very much, Ross. Now I would like to invite Ridwan to also speak to the paper. Over to you, Ridwan.
Hello, everyone. I'd like to begin by thanking Dinesha and Swati and other who worked behind the screen to make this event happen. And also by extending my congratulations to Sayeed, as I call him, from the first year law school. So it has been a wonderful paper, Sayeed, and I enjoyed, like other commentators, reading it very much. And definitely you can understand that what it needs further is polishing in terms of, I mean, fine-tuning the theories or fixing the plumbing problems, something like this. I won't take much time. I have 2 points in common with Ross and Surya, and the other things are a bit different from them. The first thing that I found common with Ross is the use of comparative law, kind of. So Ross spoke about abusive use of doctrine. So here I'm concerned about the integrity of the basic structure doctrine that has become a global reality now. I mean, the jurisdictions that never thought of importing the doctrine some 10 years ago, or 5 years ago, so they are now the part of it. So in terms of the integrity of the doctrine, so it has a link with how you use comparative jurisprudence and minus the context. So there's always a danger, and which prompts the abuse of the doctrine itself. That has happened in the jurisdiction of Bangladesh, from where you come and on which you have focused in this paper. So you have to be aware of this. I mean, how you use comparative experiences or jurisprudence when dealing with basic structure review. For example, to nudge it further, for example, so on the question of the applicability of the doctrine against an original provision of the Constitution, which is the point here in Siddiqui's case, right? There is no successful example of this phenomenon in the world. In the Honduras case, it's kind of quote packing or quote co. Then it happened, and Ross and Lange and Yaniv have explained the implications of this one. In the case of Hong Kong, so they purely rejected the idea of applying basic structure doctrine against a original provision of the Constitution. And in case of Canada, that's also the case. Probably you are aware of this. And with reference to the Canadian case, Bangladesh has a similar example of dealing with basic structure doctrine versus original provision of the Constitution. For the benefit of all of us, I'd like to mention it very quickly. In one of the cases, 3 cases altogether, on the similar ground, the petitioners challenge the reservation of parliamentary seats for women under the Constitution. And the court said, no, we can't declare the constitutional amendment unconstitutional because this reservation policy was there at the time of Bangladesh founding constitution. But in this case, what is tricky is that the petitioners, unlike the Canadian case, unlike the Hong Kong case, weren't challenging an original provision of the Constitution. They were challenging an amendment. And the amendment kept the original scheme of reserving seats for women, but extended the number. Say, for example, it started with 10, now it's 50. So the court was right, in my opinion, that yes, nevertheless, this is not an amendment, this is an original provision. What has been amended is just the number, not the original scheme. So, if you rely on comparative jurisprudence, so how the use of comparative law affects the integrity or the abuse of the basic structure doctrine, that's one point you need to keep it in mind. And another issue that I wanted to mention, and that's common with Surya, is the concept of extra textual origin of the basic structure doctrine. So to what extent it is extra textual? So it takes us to the question of wider question of what a constitution is. Is constitution as simply a bundle of black and white letters that everything has to be within the constitution? So that's the basic question also. And from that perspective, say, for example, the judges who discovered the basic structure doctrine, they were saying that they are taking the doctrine from within the constitution. They are not importing anything into the constitutional fabric. So they are simply saying that the phonetical theory of law, I mean, the judges do not make the law, simply they declare it. The judges themselves are saying that the doctrine is embedded within the constitution, embedded under the doctrine of constitutional supremacy, for example. So you have to also be aware of the implications of, sort of boxing the term textual approach within that. And because it might also lead you to reflect on the distinction between extra textual and extra constitutional. So are you saying by extra textual, are you meaning extra constitutional? Something like this. Then I have a few other very brief comments and quick also. So the paper starts with a very ambitious plan. It's good. And I was unable to read between the lines in the body, but mostly I read of them. Then if you come to the conclusion, so you need to align your fluidity of arguments in the body and the introduction and in the conclusion. I can clearly see there are some new points in the conclusion, and also you have to pinpoint. You have to be very precise about the aim you want to achieve. So that's a little bit underdeveloped right now, but it's a great paper, jurisprudential and theoretical. So that's another point. And also from the discussion and analysis, what's missing is the limited doctrine of basic structure. So it's also Ross who gave me this idea. So in one of her paper with London. So yes, there are many people that you have described that who support the basic structure doctrine, but not its application against original provisions of the Constitution or not against each and every issue coming to the court. So that's what I call limited doctrine of basic structure doctrine. And it's also tied with the, age-old phenomenon of judicial restraint, because involvement of the judiciary with the basic structure doctrine is an activity of judicial activism. So we have another theory of judicial restraint. So it's a kind of balancing. So that analysis should be there. And one final comment, you have many times used the term originalist approach. Originalist choice, for example, is a bit tricky because the term originates from American jurisprudence. And the way they use the term originalist has not been used here in your paper. Let me give you an example. In one of the sentences in which you basically critiqued some people, including myself, is this, that the originalist choice of accepting the basic structure doctrine and denying its application against original provisions of the Constitution is unattractive. So I consider myself belonging to this group, and probably you also had you in your mind, and in the footnote, right? This is fantastic. You are right, but you have to face some challenges, so you can overcome those challenges and substantiate your argument. So you have to do a little bit work on this point. So here, for example, so if I consider myself as a supporter of basic structure doctrine, but not a supporter of the doctrine's application against the original provision of the Constitution, am I an originalist? I have never thought myself as an originalist. You know why? Because if I am originalist, I can't really support the extra textual development of the basic structure doctrine, because originalists refer to the very text of the Constitution, the original provision of the Constitution. So that's a difficult phenomenon to sort of field, but you can do it. Say, for example, as Surya said, how it all depends on how you define originalism. So Surya said that originalism can be referred to previous past. So let me give a very good theoretical argument on this point, coming from Dr. Kamal Hussain from Bangladesh, and telepathically, I have just sent an essay on Dr. Kamal Hussain's contribution to Bangladesh constitutionalism through the doctrine of basic structure, just today. The paper is written in Bangla, but I published this paper in the Indian Journal of Constitutional Law at the end of last year. So in this case, which you have relied on, Dr. Kamal, who was the chairperson of the Constitution Drafting Committee, so it's actually his hands that wrote the original provision of Article 96 in the Constitution of Bangladesh, which was the issue for debate and adjudication. In Siddiqui's case, Sayeed has analyzed. But very dramatically, Dr. Kamal Hussain argued that Bangladesh Constitution's 16th amendment, which restored the original Article 96, is unconstitutional because from 1975 down to 2011, this provision 96 wasn't there. It was a provision something different from the original 96 provision. So Dr. Hussein's argument was that because of continuous constitutional practice of a different scheme for the removal of a Supreme Court judge from 1975 down to 2011, along with the socio-political context of Bangladesh, along with the constitutional preconditions or the conditions that exist in Bangladesh, this provision has become a basic structure provision.
Ridwan,
So,
I'm
yes.
sorry to interrupt.
I'm finishing.
You could wrap. Thank you.
I'm finishing. So here, Dr. Hussein's point is that 96 is not the original provision. Rather, the replaced 96 was the original provision of the Constitution. So, thank you very much. I really, really enjoyed the paper, and it's something very interesting and attractive because people writing from Bangladesh or South Asia on basic structure doctrine normally do not argue in such an argumentative way that you have done. Thank you and congratulations once again.
Thank you, Ridwan. So we will now open the floor for discussion on the paper. I have some comments myself, but I'll hold back because we already have Tarun in the queue. But before that, Sayeed, is there anything that you would want to say in response? You don't have to.
Yeah, just 2 or 3 quick response.
Yeah.
I think it'd be useful for all of us to understand the comments of the discussant. And yes, I appreciate all of your comments, and these are very thoughtful and will ultimately help me to develop the paper and to tie it up for if I have any plan to publish it in future. Just starting with the one common point that you mean as concern about abuse or overuse of the doctrine. Just I would like to notice, bring into attention that in the concluding paragraph, the first sentence of the conclusion, I categorically say that this is not a justificatory account of the doctrine. So what is happening with it? What are the risks of doing it? I am not justifying this application. It is just an explanatory account in the sense that how the doctrine actually functions. So it might be in one way of saying that I am also concerned about the potential abuse of the doctrine. So my fundamental questions was, my fundamental point was to identify that if we accept the doctrine, then we accept all these implementary consequences, and that happened or resurfaced in Siddiqui. And then about the second point about originality, just Ridwanul Hoque was my direct teacher at DU, and I had the privilege of being taught by him. So just one quick response to his point about his originalist position, and I have quoted his originalist argument right before the paragraph that he mentioned, and I say that I categorized his argument as rejectionist because what he was arguing is that Siddiqui's decision, what he has argued in his paper, that was basically published before the final judgment given by the appellate division. He is arguing that Siddiqui's decision is a marginalization and indeed defiance of the founding principles of the Constitution of Bangladesh. And then he is connecting it with the court's authority to invalidate the provision of the original Constitution because it is enacted in exercise of the original constituent power. This is the point that I actually locate to categorize him, or to categorize him in the originalist camp, because he was a kind of defending the position of the sanctity of the original constituent power, and it is very much aligned with a very brief definition that I have already given. While I have said what I would mean by originalist, I have brought this definition perhaps from Posen's work. And I am saying that it is about, oh, just sorry for that. I just simply argued that this is about defending this sanctity of the text that is passed in exercise of the original constituent power. This kind of sense is broadly defined as originalist position. That I should definitely develop, and I appreciate Ridwan sir's advice on that. I will take a very specific and elaborate definitions on that. And the final point about the extra-textual nature, because it is coming both in Ridwanul Hoque's and Surya Deva's argument. I just again would like to clarify that how the doctrine originated in Kesavanando and how it was adopted in or migrated in different jurisdictions due to all these unstable or malpractice in amendability politics. It was not my questions. My concern was how the doctrine was originally developed. So again, it was a kind of explanatory account rather than justificatory, that how it should go and how it should function in the current context of democratic instability all over the world. And Rose's, just to be brief about Rose's questions about compromise and about this kind of support of constitutionalism and the critique. And Rose herself mentioned that it must be difficult for me to answer. Yes, it is. But one point is that the basic structure doctrine itself is the symptom of the anomalies, of the deeper problem in the liberal project of constitutionalism. So if I say that all these anomalies are there and basic structure doctrine contributes to this, I would rather say that basic structure doctrine is rather the symptom of all the problems rather than being the cause of it. So even if it is the misuse and there are overuse of it, so this is not the cause, but the symptom of the liberal constitutional problem in the liberal constitutionalism itself. So I am wrapping up, and Dinesha, it's over to you.
Right. Thanks, Sayeed. So before we open up the floor for the attendees to also comment, let me also just quickly remind all of us that the objective of our forum is to ask questions to help the author. So when we ask questions, we should ask the questions based on our reading of the paper and with the intention of helping the author. So with that, let me invite Tarun and then Raibol in that order, please. Tarun.
Thanks very much, Dinesha. Sayeed, this was a fantastic paper. I really enjoyed reading it. You write well. You have a clear writing style. It's very well structured, and it's quite instructive for our other early career authors as well to feature it at this forum. I can also imagine that sort of outing yourself with a paper in a public forum early in your career can be quite daunting. So hopefully, we have provided a friendly space to put robust but kind pressures on your ideas. I have some stylistic and some substantive things to say. The first, and this is a lot of the pressure that you received about the normative payoff of your paper. And, in the conclusion, you're quite right in saying this is not a normative paper. But my view as an author is that if one person misreads you, it's their problem. If 5 people misread you, it's your problem. And I think you need to front that claim. You need to repeat it many times. You need to put it in the framing and in the abstract. Because this especially happens when you're doing something that is alien to the literature. The literature does not do what you're trying to do here. Most of the literature is hands-on and normative. So you have an additional burden of constantly reminding your readers that this is not what I'm doing. One helpful way of doing that might be to early on distinguish between the conceptual question, which is, do constitutions have a basic structure and how to find it, from the institutional question, which is whether that should be enforced, by whom, and how. Now, the two questions don't necessarily track each other, right? There is both intellectual and political payoff in thinking about whether a constitution has a basic structure and what it is, even if there is no judicial enforcement of that basic structure doctrine. Right? And I believe the Pakistani doctrinal position, I think, I'm not 100% sure, is basically, even judicially at the moment, that Pakistan has a basic structure, but the court shall not enforce it. So if you draw that conceptual and institutional distinction up front and say, look, I'm not saying anything about the institutional question in this paper. I'm interested in the conceptual question. And I'm not interested in the shoulds and the whys. I think it'll help you and also further the debate that this is a question worth thinking about for its own sake, irrespective of what we think judges do or don't do with this. So bracket it more explicitly and more early in the paper. The second thing you might also need to do in terms of caveat making in the paper is to say early on that you're not trying to present a comprehensive theory of the basic structure doctrine, right? That you're dealing with one small strand, one discrete issue that has come up a couple of cases from India and Bangladesh, right? So just clarifying that you're not being ambitious, and I think that's the right thing to do. One article can only do one thing, especially early on. Will also hedge against some of the types of worries that have been pointed out to you. The third thing I would say on style is that while I think your theoretical discussion is very clear, especially given that you're dealing with very abstract, dense theory, you have a way of communicating it very clearly. I still think that more illustrations will help further with your argumentation. So I'll give two examples where you differentiate between the textual structuralism and purposive structuralism. I would have really liked to see illustrations to show what hangs on this distinction. Right? Why? An example where using a textual structuralist and a purposive structuralist distinction makes a difference. Right? So this is somewhat tracking Surya's argument that the distinction may not be a sharp one, right? And that can be true, and the distinction can still be useful. So not all distinctions are sharp, but you at least need to show that the distinction, at least sometimes, is evident, self-evident, or clear in cases. And I think two examples there would help. The other thing, so I thought you described the visible and invisible distinction quite clearly, but I kept thinking, does this track, or is it different from the written and unwritten norms distinction? Right? So again, just a couple of examples there might have helped the reader along. And just a couple, so I'll just make two substantive points. They've both been mentioned, but I'll elaborate on them. The first is, I think Surya mentioned Justice Sinha's point with the temporal argument that the Constitution today is not the Constitution of 50 years ago. And if you subscribe to that, then as a corollary, although one that still needs argumentation, is that the basic structure of the Constitution today is not the basic structure of the Constitution from 50 years ago. There's clearly a direct connection between that thought and the discussion on transformative or militant constitutionalism, right? So militant is obviously the term that Gary Jacobson uses. Transformative constitution talked about a lot, but if a constitution by its own lights wants to change material realities, then it will be a different constitution for a few years down the line. And I was just wondering whether that discussion helps you in the Ganpat Rao inquiry. And a different way of asking is, if the amendment in Ganpat Rao was reenacted, right, purposes were brought back, would they be unconstitutional? I think there would be, right? Because and then it would be a direct analogy to the Bangladeshi case. The second point I want to insist upon somewhat is Roz's point about constitutional polyvocality. And again, I think Gary Jacobson's work on internal disharmony is helpful. Yeah, look, all this label-based demon fighting, liberal constitutionalism, unhelpful, etc. That's too broad, too vague, and too unhelpful to further the debate. Talk about concrete issues here, right? Whether it's liberal, socialist, whatever. The fact is that constitutions are messy exercises in politics, and sometimes strategically have to speak in multiple voices to different constituencies. Gary Jacobson has described it as internal disharmony of constitutions. In the Indian context, Aditya Nigam has called it the polyphony or polyvocality of the Indian Constitution. And these are important both to the stability of the Constitution, because different groups buy into it. Ross's work on deciding not to decide is very much in line with that kind of incrementalist strategy, but also their legitimacy, because that is how they have passed through a consensus, right? So it can't be wished away as a problem of liberal constitutionalism. Whatever framing you do, whatever your ideological, in the Chinese constitution, you have free market and socialism coexisting, right? So this is not a liberal problem. This is a problem with creating a constitution for any complex, divided society. And I think you might need to address that. One of the worries about your conceptual take might be that it seeks to resolve these seeming contradictions and coherences. And they may be anti-constitutionalist or problematic, just ingrained. And you can flag this. I'll shut up here with one final thought, which is that in these workshops, you get thousands of comments, and obviously we all look at your paper from what interests us. Your paper was very good in that it was not trying to do too much. I would really warn you against trying to solve all these problems in the next revision of this paper. Take the comments away, think about them, park some for later, but I think it's really instructive, and this is to other authors who are in the room as well. One of the problems we have in this forum is the first paper of early career scholars trying to, solve all the problems in the world. What's good about your paper is its narrowness of ambition. And I think I would preserve that even as you try to respond to what's particularly key for you in this paper, and leave the others for another day. Thank you.
Thanks, Tarun. I think as someone who struggles with the problem of wanting to solve the world's problem in everything that I write, I really did appreciate that about your project, Sayeed, because you identify the gap using the case, and then you move sideways and upwards and zoom in and zoom out, keeping your focus in mind, and you take your reader with you. So I appreciated that very much. Raibul, you raised your hand. You may make your comment now.
Thank you, Dinesha. Right, actually, I'm from Hong Kong, basically. So, right, Sayeed is my colleague in Bangladesh. And so just I would like to add something here that, yes, as a student of comparative constitutional law, I'd like to say that, yes, the idea of, basic structure, yeah, there is always, the debate to which group basic structure. Well, I believe that even the liberal interpretation of constitution and constitutionalism both can help to fit, basic structure, either with originalism and or with living constitutionalism. Both the things can be okay for basic structure. But my point is that, yes, Professor Tarun already, told that basic structure can be the option. And Professor Rosalind Dixon also said that, yes, according to the, in order to avoid the disharmonic constitutional provision, basic structure can be the one option to mitigate all these things. But my point is, just you need to, look at the place, the country, the time, and the location of the origin of basic structure. Basic structure basically originated by the Indian judges at that very time, when actually it was a huge politicization of justice. How judiciary was grabbed in political factors, the external forces. So at the same time, vice versa, basic structure is still carries the, the nightmare that, yes, Rosalind Dixon has already mentioned that there might be the nightmare that there can be the lack of integrity, like in case of applying this, basic structure norms. So the judges can be the, sometimes unnecessarily, enthusiastic. And this thing happened in case of Bangladesh, especially if you just look at, according to, the 16th Amendment case, you can find there, the Justice Sinha, when that is only the, I mean, the landmark that Justice Sinha has provided. But when Justice Sinha actually, I mean, gave the judgment, he actually didn't receive any good treatment from the government. But before that, when Justice Sinha was not that much radical or very, I mean, like progressive in case of delivering his judgment, everything was quite good for him. So the point is just my fear that I would like to say that side, please, I mean, if it is possible, just don't forget to look at the concept of judicialization and politics again, and the politicization of justice. Both the angles you can also, I mean, just juggle. Yeah, thank you.
Thank you. I don't have anyone else in the queue, so while I wait for comments, I just wanted to make the following, give you the following feedback side. So I came to this paper as someone who's still learning about the basic structure doctrine, and also someone who's learning about constitutional developments in Bangladesh. And you mentioned in your draft that you are hoping to publish this in a journal. So you will be speaking to people like us as well. So I was wondering whether you want to give a little bit more detail about the history of the amendments, about the broader context of judicial politics, the dynamics between the executive and the legislature, judiciary, so that we can follow and appreciate the claims you make better. Is there anyone else who has any comments for Sayeed?
Dinesha, can I just say something on
Yes,
the
of course.
publication advice? Sorry, I meant to speak to it because you invited that advice specifically, Sayeed. I do think that the forum, in terms of revise this paper, and in the next round, you should settle on at least a target journal before you start revising. I would think that ICON or the Indian Law Review are the most obvious options for you to consider, but they will need significantly different, not significantly, somewhat different types of framing of the issue. And I think that, you know, the way it's pitched at the moment at a high level of abstraction, Ros will correct me if I'm wrong, but I think that it will probably be fine for ICON. You will still need to give some context, as Dinesha says, but not a whole lot more. And you also need to make sure that the paper still stays within 10,000 words or so. I think ILR will probably require some more South Asian grounding, and that wouldn't be hard given the cases you deal with. There's already enough South Asian context in the paper, but I think if I were you, those are the two journals. And despite sort of wearing an ILR journal editor hat, you know, it's a great journal. It's not ICON. So if I were you, I would probably send it to ICON first, would be my advice. But Ros, I don't know if you wanted to correct anything I said there.
No, I mean, I'm happy to talk to you more about it, Sayeed, in Sydney. I would just say you should definitely publish it. When you said, I'm not sure if I'll publish it, you should definitely publish it. It's really interesting and it's very worthwhile. So, you know, we can talk a bit more about the pros and cons of different outlets. I mean, generally, I think there is a trade-off for one's career between how high you aim and how long you wait, and with the chance of success or failure that goes along with that. And it can be generative, but it depends whether you need publication sooner or later, all those things. So I'm happy to chat about that. But I agree with your point, Tarun, about a sort of more global framing versus a more regional South Asian framing. But I would say the most important thing is it's really interesting. And, you know, there's a little bit more work to be done, but not a huge amount, and you should definitely publish it.
Thank you, Ros. I can reinforce that, the fact that this must be read by others. It's really waiting to be read in that sense. Swati?
Thanks, Dinesha. Thanks, Sayeed. That was an interesting paper to read. I actually learned a lot, not just about the Bangladesh context, but you kind of gave me a new way of organizing my thinking on the basic structure doctrine because of just how you structured the paper. I also really enjoyed Ridwan, Ros, and Surya's comments. So mine actually dialogue a lot with what your commentators have said and what Tarun has said about the normative payoff of your paper. So I understand that you're going for an explanatory endeavor versus a justificatory endeavor. But to me, again, just to echo what they're saying, I don't think the two have been disentangled enough in your paper, because some of the explanatory conclusions that you draw necessarily connect to a normative foundation. So when Ross was saying, you know, prioritizing structure over text, there's a normative sort of moral obligation on yourself to justify why, you know, why that makes sense, or just why that is the best explanatory account for what's going on in the case that you're particularly interested in. Tarun mentioned, you know, with the basic structure, there are different controversies that it engages. So I always see it as sort of engaging the who, what, why, when kind of questions. So I feel like what's less controversial is for us to agree that the Constitution does have a basic structure, that it does exist outside of the text. There are principles, norms at play that are outside of the text. But it's obviously the what do we do with that identity, that basic structure next, that's the real engaging question. So here I felt like your paper kind of eluded the two, sort of multiple controversies relating to the basic structure into one big question, and again could benefit from just disaggregating them a little bit. So at some points I thought the controversies that you were speaking about were focusing on the how do we extract what belongs to the basic structure or what is a basic feature of the Constitution, and at other points you switched your attention to the controversial question of what do we then use this to do? Can it be used to invalidate this particular original Constitution, whatever original Constitution means? Or can it be more restricted in what it's able to do? So just to kind of be clear about the particular controversy you're addressing about the basic structure doctrine or basic features doctrine might be a good thing to do, because if you're looking at, like Tarun was saying, you know, a single paper can't address everything. But if you're looking at one way of focusing the paper, then it might be to decide where in the controversy you're locating your discussion and then target it towards that. One more sort of structural question, I get, sorry to use the word structural, but it's a structural question about your paper is, you know, sections 2 and 3, when you're looking at sort of Indian jurisprudence and German jurisprudence, I think before you go into that jurisprudence, it would have been nice to have the Bangladeshi context set up for us before, and then to play out the Bangladeshi context when you're engaging with the other jurisdictions and what their cases are deciding. This is more of a how do we weave in the comparative work into our papers, but it's just something that, yeah, maybe I'm sort of going with what is my style in doing that. But I think for me, I was missing that link to just so I could get a sense of like where you were going when you were looking at the Indian and German jurisprudence, where you were going to go with that, and how you would then link it back to Bangladesh. So yeah, so those are just some comments, but thank you for sharing your paper with the forum. It's not an easy thing to do when a paper is in an early stage, especially to expose it to just such incredible discussants. So thank you so much for doing that.
Thank you, Swati. Sorry about the background noise. So I think in the absence of any further comments, we will wrap up, because I'm also mindful that our Australian colleagues are in this sort of latter part of their day. So I just want to say a big thank you to Sayeed for sharing your work in progress, to Surya, Ros, and Ridwan for their generous comments, for making the time to be with us and make this forum today. Thank you also attendees. It's always great to bring this virtual community together and sort of aspire to have South Asian conversations. So thank you very much for being with us. I also want to thank Swati, Tavini, and Animesh for hosting the workshop so well. Thank you very much for that. And before I close, I want to announce that our next workshop will be on the 24th March. Please look out for further details, which will be announced via our usual platforms on Twitter, Facebook, and email. So with that, I would like to wish all of you a pleasant rest of the day. Thank you.
Thank you, everyone. Bye-bye for now.
Thanks, Surya. Bye. Thanks, Ross. Saeed, thank you.
Thanks, Rose, Surya, and Ridwan, sir.
Ridwan, thanks very much.
Well done, Sayeed.
Thank you.